What are we doing?
Your Honor, there is a resolution in this matter to which Ms. Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange, count 1 will be dismissed.
That's an operating while visibly impaired.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Angel Wilson.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much?
No.
What did you have?
Tequila.
Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon? You need to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
Buckle up, because this isn't just another DUI case. Today, we're diving into a courtroom shocker where a young woman, Angel Wilson, pleads guilty to operating while visibly impaired after flipping her car on a freeway. But that's just the beginning. We got disputed blood tests, Tether malfunctions, and a judge who isn't buying excuses. It's a spiral of poor choices, second chances, and the limits of the court's patience. And just when you think things couldn't get worse, bam, a second bond violation hits. Is this a malfunction, a misunderstanding, or a masterclass in denial? Stick around as we unravel the chaos, expose the contradictions, and show you exactly why the judge says she's lucky to be alive. This one's got all drama, defiance, and a whole lot of courtroom heat.
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood test results?
Oh, yes. I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond violation.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual SCRAM report from that company. I did discuss it in detail with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof that she was at work as a CNA during that time. Further, both in the bond violation report I received from...
Let's pause right here. A blood alcohol level of 0.84? That's over 10 times the legal limit. An astronomical reading that can mean life-threatening intoxication. But Angel's memory is conveniently foggy. I don't remember how much I drank, she says, only recall it was tequila. This isn't a casual lapse. It's a dangerous blackout scenario, and the judge knows it. That number isn't just a detail. It paints the scene of a crash that could have killed her or someone else. This isn't just about impaired driving. It's about accountability, and this court is about to bring it full force.
SCRAM, as well as my client confirmed, she received a new SCRAM Tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new Tether on May 28th, and then on May 31st, there was an alleged tamper.
A car rolled over on the freeway. That's not just bad luck. That's a terrifying consequence. The judge immediately challenges Angel. That didn't spontaneously happen. And she's right. This is an offender bender. It's a life-threatening crash caused by intoxication. It's easy to gloss over these words, but think about it. Someone could have died, and this isn't her first run-in with the system. The judge hears this story every week, but when it involves a rollover and tequila, even they look stunned. You can feel the court's patience wearing thin, and the tension is just getting started.
That started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking
What time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
No, Your Honor. It was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, counsel?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation. If the
Okay,
court
she'll
is-
get her hearing, but she's gonna be remanded pending that. I mean, I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in April. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with SCRAM. She did receive this new Tether just on the 28th, and the 31st is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the SCRAM Tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now.
Here's where the story takes a sharp turn. Angel's attorney claims she was at work during the alleged tether tampering, clocked in at 6:54 a.m. and out by 3 p.m. Yet the violation alert lasted from 7:10 a.m. to nearly 10:30 p.m. So what gives? A malfunction? A misunderstanding? Or a lie wrapped in technical language? It's not just about whether she drank. It's about whether the court can trust her, and the defense knows it's walking a tightrope, pushing for a hearing, clinging to timestamps and screenshots. But the judge? She's already heard enough.
On my second violation, both involving alcohol, you want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then I put her on this. She comes for this charge. She's drinking. She serves her time for drinking. I'm back, and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending a hearing?
She denies alcohol use, and we believe it is a tether malfunction, as you're asking for a hearing on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me the in custody sentencing date, first of all. Changing her sentencing date, what?
Boom. The judge explodes with frustration, and who could blame her? She reminds everyone. This defendant rode a vehicle while drunk, was given a second chance, violated bond once, served time, and is back again with another violation. The courtroom is no longer a place for negotiation. It's become a battleground for credibility. And Angel's credibility is running on fumes. The judge's tone sharpens. How in what responsible world would I let her bond continue? That's not just judicial reasoning. That's a reality check. You don't get endless chances when your choices risk lives.
25th at 9 a.m.
Sentencing will be June 25th, 2024 at 9 a.m. We will move that, got a time for a bond hearing I can do. The 25th, my bond hearing date. That's my date that I have. Right.
The 12th is the sentencing. Yeah.
Well, but the 24th, we have trials and
Yes.
right. We'll set a bond hearing on this.
The judge isn't just setting dates. She's setting the tone. A formal bond hearing for June 24th. Sentencing bumped to June 25th. And a new bond set at $5,000 cash. These aren't just logistics. They're the court's last line of control. Angel's out of rope. Her excuses are paper thin. And the system is closing in. The court is now balancing public safety, accountability, and fairness. But make no mistake, leniency is off the table. She's getting one last shot, and the consequences are about to get real.
June 24th, 2024, 9 a.m. Pending the hearing, will be set in the amount of $10,000, make it $5,000 cash.
Let's talk about that tether. If your alcohol monitor goes off, do you trust the tech or the person wearing it? That's the big question here. Angel's team says it malfunctioned. The judge says she's heard that song before. Who do you believe, the data or the denial? Drop your thoughts in the comments. Have you seen cases where faulty tech really did ruin someone's bond? Or is this just another blame the device defense when the truth is harder to admit? We want to know. Sound off below. So what did we witness today? A defendant who flipped her car on the freeway while intoxicated, pled guilty, violated bond twice, and now faces a court system that's clearly had enough. The judge called it like it is, reckless, repeated, and lucky to still be alive, whether it was tether tech or truth-bending tactics. This case exposes a thin line between second chances and final warnings. And Angel's running out of both. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping breakdowns. You won't believe what's coming next.